Hi, my name is Cheryl Sattler. I am an education advocate at Legal Services of North Florida in the Tallahassee office. This is a module on understanding student discipline law in K-12 schools. I hope that you already saw the module on the background for Florida schools because you'll need to understand what kind of school is enforcing discipline on a student. So if you didn't, I recommend that you go back and watch that very brief introduction. Please note that this presentation is based on federal and state statutes, regulation, and case law that are current as of June 2023. And so obviously, before you apply these, please check for changes and updates. This presentation provides legal information, not legal advice. For case-specific advice, please contact Stephanie Johnson, Senior Managing Attorney at the Tallahassee office. You can also reach her by email at steph@lsnf.org. So what I'd like to do in this module is a couple of things. I want to give you a background and an understanding of the things that you'll see in a discipline case. And of course, you won't see all of them every time, but better to know than not know. And then secondly, I'd like to give you some tips and tricks on how to approach a student discipline case and how to argue for that student. Everything that we're going to talk about today is based on Florida statutes. Discipline is a very local decision. And so not only are you going to want to look at the Florida statutes, but also, and here's some more Florida statutes. So it is a school board responsibility. It is a local district responsibility. There are corresponding state rules. And then the most important thing is not a statute and not a rule. Because here's the thing, Florida statute leaves districts with a ton of discretion in terms of student discipline. So when you look at the actual statute, it will say things like a school board must have a discipline policy, and it must create a student code of conduct, and it must give that student code of conduct out. But the student code of conduct actually is probably the most important document for you to find and read when you start a discipline case. You can generally find it on the district website. It is a long document, but it details all of the things that a student can be suspended for, expelled for, what the processes are. It's quite comprehensive. And you are likely to be the first person in that case to ever have read that document, even though it is distributed every year. It's not exactly easy reading. So if you're not worried about discipline, why would you? So the code of conduct actually must follow specific statutory requirements. So the school board must adopt these rules, and the code of conduct has to include consistent policies, specific grounds for disciplinary action, what those disciplinary procedures are, student rights and responsibilities, and specific prohibitions on drugs, firearms, and violence against school officials. So let's talk about who enforces school discipline. So if you pick up the phone and it's a client calling to say, or a wannabe client calling to say that their child has been disciplined by the school, hopefully that discipline has come from the principal. And that's a good thing, or a teacher, someone within the school, because you want to get this case as early as possible, because your avenues for supporting the student diminish the further along it gets in the process. That is true with anything. So the principal is in charge of discipline at the school site. The principal is then responsible to the superintendent of schools, and then school board oversees the superintendent and actually weighs in on expulsions. You should not be hearing from school resource officers, and you should not be hearing from the threat assessment team. I'm going to talk about these things because they're in our schools. They are sometimes mistakenly used for discipline, and they are not supposed to be. So it's possible although not a great strategy, that you can use the involvement of an SRO to argue against discipline. However, it's really just worth noting who all the players are. So let's talk about SROs, school resource officers. So every school is required to have some sort of a safe school officer. That safe school officer can or may not be an SRO. Typically, a school district will contract or have a memoranda of understanding with the local law enforcement agency. These are typically not school personnel. They are typically uniformed officers. And importantly, and we're going to talk about records in a module on student privacy, but records made by the school resource officer are not considered school records or educational records for Freedom of Information Act purposes. And what that means is that they're not protected. So the protections of FOIA only extend to educational records. In addition, the school may have guardians. The Guardian program was developed under the Marjory Stoneman Douglas Act, which we will talk about a lot later. That means that they have school staff who are armed. Those staff have had to undergo required training by the sheriff, and both guardians and safe school officers have law enforcement powers, so they can arrest. Hopefully this does not come up, but let me at this point say that discipline cases often have two components. They have a civil component, which would be suspension, expulsion, school-based discipline, and they may also have a law enforcement component. So this presentation only talks about the civil components, but you may very well be dealing with a public defender with criminal charges. Okay, so just as a reminder, school resource officers are not there for discipline, they're there for protection. But then you get into this other interesting quote from the statute that SROs have to follow district school board policies and coordinate with the principal, but at the end of the day, they're responsible to the law enforcement agency. So unfortunately, what ends up happening a lot of times is that you'll have an SRO who will be trained in a different method of de-escalation or a different method of safely transporting students, and certainly a different method of interacting with students if they've had that training at all. And that can cause some conflict and it can cause some difficulties for kids. But hopefully, your discipline issues will not involve the SRO. So there are obviously different levels of discipline in a school. And this list is from best to worst. So the best thing that can happen to you in terms of discipline is a classroom referral. And that is a formal written referral sheet. It is cataloged in the school's files, goes into the student's permanent record. But typically it's, you get sent to the principal's office, you might get a talking to, your parents might get a phone call. You might have to make an apology or write an apology, but it's not overly serious. I did want to note that you can administer corporal punishment in some Florida school districts. If you have a child who is punished by the use of corporal punishment and a parent is upset about it, the first thing you want to check is whether that school district has a policy allowing corporal punishment. So again, not considered a very serious problem. Where you start to hear from parents and DCF workers is when a student is suspended. So we're getting more serious. Then there's alternative placement, which is kind of not a punishment, but it's related to these punishments. So we're going to talk about that too. And then, of course, the worst thing that can happen is a student is expelled. So I've talked to you about classroom referrals. Obviously, that student is not getting the gold star. And a classroom referral can result in a suspension. So we have two kinds of suspension I'll talk about, ISS and OSS. That is what they're called in schools. They stand for in school or out of school suspension. And, it's just not education unless there's some clever little abbreviation, because boy, do we have a lot of crazy words. Okay, so ISS versus OSS. In school suspension is basically when a student is taken from the classroom and placed in another room with another staff member. They generally are doing work. They are limited to 10 days. It is not considered a change of placement for IDEA. If you don't know what a change of placement is, do not worry about it. We are going to go deep into IDEA and discipline of students in special education. But just so you know, they're basically in the same building. They're not participating with their class in anything. They're being watched while they do schoolwork. Then there's OSS, which is more serious than ISS. And that is the removal of a student from anything having to do with their school. The school bus, the school grounds, the football game, the cheerleading competition, whatever it is, they are not there. They are not on campus. There is a 10-day limit to each suspension, and they are supposed to get specific homework assignments to complete. Now, there are no exceptions and no specific provisions for students who do not have parents at home, students experiencing homelessness, or students who are in foster care. So this can become an issue sometimes, particularly with certain kinds of placements. A suspension is not the end of the world, and it certainly beats an expulsion. You can also, by the way, be suspended from the bus. And again, this is particularly hard on low-income parents, parents who are challenged in terms of transportation, students experiencing homelessness, students in foster care. So you can be messing up at the bus stop, that's included. You get written notice. There is a little caveat here that if a student is in special ed, you need to make sure that if their IEP, and again, we'll talk about all these things, but if their individualized education plan says they have transportation as a related service, then the school can't use the bus, but they still have to transport the student. So that's fairly important. We think about suspensions as being only about things that happen on a school campus, but that's not true. You can mess up off campus and have it lead to suspension and also expulsion. And it typically, and this is something, so principals and superintendents hate this when a student is charged with an off-campus felony and they want to get rid of the student because they typically immediately think the student is a danger. But not only the charging of a student with an off-campus felony is not the end of the story. That felony also must be shown to have an adverse impact on the educational program, discipline, or welfare in the school in which the student is enrolled. So you could think about if they're arrested for a gang fight and it's off campus, they would probably be able to successfully argue that a student who is a known gang member attracts other gang members to campus and that the potential for violence is very high. But make them prove that. And the way that they prove that is they have to have an administrative hearing. And obviously, if the court has acted, this is kind of interesting because, this is all supposed to happen very quickly. And we know that the courts do not act that quickly. But if the court immediately were to dismiss the charge or determine that the student is guilty or innocent, then that would factor into the decision. But you'll note that the decision has to be in writing within 5 days. So it's more than likely that at that administrative hearing, there is no information from the courts. The Student may not have even been to court. They're just charged. So, that argues in your favor. And the students, of course. There are certain things that are annoying, but are not suspendable offenses. Okay. If you are late, you have unexcused tardies, you're absent a lot, you're truant, and this is different but important, if you are undocumented, you cannot be suspended for that undocumented status. There's a module on the rights of students who are immigrants, and we have an unqualified right under Supreme Court case law that an undocumented immigrant or an undocumented person has an absolute right to educational services while in the United States. Moving along, suspension does start the due process. And you noticed before that when a student got a referral, the parent was notified. But here we start getting into serious due process. You need to make, and this is when I say you, the principal or someone at the school, could be a dean, needs to make a good faith effort to immediately inform the parent. They need to create a written document with the suspension and the reasons for it in writing within 24 hours. And that is, they have to initiate the sending within 24 hours. They also, within that same 24 hours, have to send that up to the superintendent, because, the superintendent is going to be the next level. Okay, so, but before they suspend, the school is supposed to have made a good faith effort to employ parental assistance or other alternative measures. And so what that means is they've had a conference, they've talked to the parent, maybe they have adjusted the student's schedule, maybe they've added some counseling services. They have to have tried something. Suspension is serious. Student misses school. They have homework, but it's not all the work or all the learning they would actually get while on campus. And so you want to actually look and see, was there a good faith effort? There are exceptions, of course. If it's an emergency, a disruptive condition that requires immediate action, or a serious breach of conduct, the good faith effort does not have to take place. But, by and large, most things should have room for those good faith efforts. All right, so continuing on with the notice, you also need oral and written notice to the student before you suspend them, and then the student should be given an opportunity to present their side of the story. This is an informal meeting. This is you sitting in the principal's office. There is no counsel required. There is no parent required to be there. This is an interesting question, whether or not this is a custodial interrogation. Here's the thing, that if you are in a position to counsel a child client or a parent before this happens, tell them not to talk. Tell them to stop talking. Because while they're saying whatever their side of the story is, that is going to be used against them in any way that they can use it against them, while they're not being counseled by anyone, while there's no one in there. So it's not a great situation, and you don't want to say very much. All right, we talked about good faith efforts. So I just wanted to show you a little bit of information, a little bit of data on suspension trends in Florida. I'm going to tell you how to read this chart. So there are 3 charts, and they're all from the same school year, and they are just by different student groups. So if you look at this suspension trends in Florida, if you look at the top line, you'll see total student enrollment. And so using the key at the bottom, it tells me that 21.9% of students enrolled in Florida are Black or African American. Okay. Then moving over, it tells me that 35.6% of students enrolled in Florida schools, these are public schools, are Hispanic. And then that 35.3% are white. Okay, great. But then if you move down to one or more in-school suspensions, you see that Black students, although about 22% of the total population, represent 35% of one or more in-school suspensions, 36% of one out-of-school suspension, 43 almost percent of more than one out-of-school suspension, and then 32% of expulsions without educational services. So what that tells me is that an African-American student is twice as likely to have more than one out-of-school suspension than if this were equitable to their share of in the student population. On the other hand, if you look at the other thing, you also see that it's white students who are 35% of the population, but they represent 45% of those expulsions without educational services. So interesting. Let's look at students with disabilities. So students with disabilities represent about 15% of Florida students. They are suspended 30%. Again, out of school suspension, 30%, more than one out of school suspension. You can see we're getting really high here, almost 40%. And then expulsions without educational services. This is interesting because there's a very strong requirement to ensure educational services to students with disabilities. So we're not going to talk about that here. Just want you to see where the statistics line up. And then we'll take one last look at gender. And so you can see there's a fairly equal distribution of girls and boys, slightly more boys than girls. But when you look at females, they are suspended less often, out of school suspension less often, more than one less often, still less often, and then without educational services, about a third. So, and boys, you probably are not very surprised by this, are disciplined much more often. So I give you these data to say, and these are statewide data, but the same data are available by school and by district. So if you have a student with disabilities who is African American and male, you, or any of these things, you may want to look at these statistics and in your argument point out the fact that this school is disproportionately disciplining students based on characteristics. So just one more point to make as you try to, cobble together some information to support the student and a lesser form of discipline. Alternative placement is not really a thing. There are types of schools that are considered alternative placements. Sometimes they're schools, sometimes they're programs, sometimes they're considered dropout prevention programs or credit retrieval programs, lots of names, but in common, they are a place where a student is removed from their original school campus. They're not expelled, but they're placed in this different educational setting, and it can be a virtual school. So you can get here a number of ways. You can get here as an alternative to expulsion, and basically anything beats expulsion. We'll talk a little bit more about alternative placement in a minute. However, there's other ways to get there. You can have a series of suspensions to be placed there, but the principal has some flexibility. If a student is failing, if they're absent a lot, if they have a history of disruptive behavior. And because this is a serious thing, the principal can't just move a child from their school to this alternative placement. They have to notify the parent in writing. And importantly, the parent is entitled to an administrative review of that placement. You want to make sure that the parent doesn't waive any of these rights. You want to make the district and the school prove why the student can't be successful with supports if necessary in the environment where they are. Okay, so in terms of advocacy, my issue with alternative placement schools, and because it's my issue, is that they have really low graduation rates. The school instructional quality varies a lot. Most of the time, it's students in a room on computers with a staff member to help them log on and off, occasionally provide some academic support, but that varies a lot. So what you want to do is find out the required length of time and try to get that for as little time as possible. If your student is involuntarily assigned and you go through that administrative hearing and the district says, no, kid needs to be in this alternative school, that is appealable to the relevant DCA. If this is a student with disabilities, they are still entitled to everything on their IEP, and those services and supports need to be in place. Okay, let's talk about the big one, expulsion. It's the removal of the right of a student to attend a public school for a period of time not to exceed the rest of the school year or term and one additional year. So it can be a year and a half. You can be expelled with or without continuing ed services. That's largely a special ed issue. And this does get reported to the DOE so that we can create charts like the one I just showed you. So typically, students are expelled for drugs, threats, sexual harassment, disruptive conduct. That's a biggie, and it is very open to interpretation. The third violation of school dress code. So that one's kind of a surprise for a lot of parents. And then, as we discussed, criminal charges off campus. So I said that principals and superintendents have a lot of discretion. Sometimes they don't. There are what we call zero tolerance offenses. And this is a case where a student has to be expelled for at least a year. And unfortunately, this also requires, under statute, a referral to criminal justice or juvenile justice. And those are weapons and threats or false reports. So we are not messing around with those. Note that I've given you the statutory references for definition of weapons and definitions for threat and false reports. Zero tolerance has changed over the years, and not every district has kept up with these changes. So it's important to note that zero tolerance is not intended for petty acts. So if you find that a student is being recommended for expulsion and they say it's zero tolerance, you want to double check that. Like I said, not every district has updated its policy. So if it's nasty, but not zero tolerance, they need to have alternatives to expulsion. Okay, and the statute here names some. So if you look here at the bottom, it says it shouldn't be about a minor fight, minor disturbance, and PS, let's not be expelling kids in a discriminatory fashion. Let's talk for a second about this required consultation with law enforcement. So law enforcement is on our schools and in students' lives more all the time. And zero tolerance is one of those places where law enforcement and schools definitely overlap. So you have the policy. The policy must require the school's threat assessment team, we'll talk about those in a minute, to consult with law enforcement. And they're looking for patterns of behavior based on previous acts or really bad acts that basically would make this kid likely to be the next school shooter. Then there's the next level, and we get into misdemeanors. And if a student commits more than one misdemeanor, the threat assessment team has to talk to law enforcement to see if there should be a formal charge filed, essentially. And here I've listed the misdemeanors that are required in the statute. So as you can see, again, disorderly conduct, simple assault or battery, some of these trespass are pretty minor. In 2022, due to a lot of things, including work that continues on the Marjory Stoneman Douglas Commission, the legislature changed the definitions of school bad acts. So now the criminal definition is a school crime definition. So a battery is a battery is a battery. On the one hand, that's good because we have consistency. On the other hand, now we have students charged with batteries on school campus, where before we might not have called it a battery and it might not have come to law enforcement's attention. Okay, in terms of expulsion, there's another, so you say, well, districts have a lot of discretion. And they're going to say, this is about keeping the other students safe. And you should know that there's kind of an outside level to this discretion. So districts are allowed to expel kids who commit a felony or do a delinquent act, which would have been a felony if they had been an adult. If they were charged as an adult and had adjudication withheld, or they found guilty of a felony. So these are situations where there is still discretion, but your argument is much harder. It really depends on what the act is. So there's particular expulsion triggers, off-campus felony arrest, and under statute that law enforcement, not necessarily the arresting officer, but that report is going to be sent to the superintendent. So wherever you get arrested, superintendent's going to find out. And a serious breach of conduct, a big fight. We've talked about drugs, we've talked about weapons. Fighting is honestly the biggest thing that happens. And sometimes that's mutual and sometimes it's not. And both of them are trigger expulsions. So you can't just say, go home, I don't want to see you anymore. In order to recommend an expulsion, the principal must create a detailed report. That report has to tell you what alternative measures were taken before they can recommend expulsion. So if you have a student who is recommended for expulsion, you want that report and you want to talk to the student about the alternative measures that were taken, if any. Sometimes the school likes to talk about all the wonderful things it's done for a kid that maybe weren't that big of an intervention and obviously didn't do the trick. Okay, the expulsion process. This principal recommends the expulsion and sends that on up the chain of command. If the superintendent agrees with the expulsion, he or she recommends to the school board. And so even though you can only suspend a student for 10 days, if you have a pending expulsion recommendation, you can extend that suspension. So this is a kid nobody wants back on campus. Great. They're not letting him back on campus. But, and here we have absolute, very strict due process. There is an expulsion hearing that is governed by statute that has to take place. This is worth looking up. Each little detail of any kind of due process is worth making an argument. School board typically discusses expulsion in a closed session. So if you look at a school board agenda, it will say, proposed expulsion of, and then it will either be redacted or it will have a student number or some sort of code will be used. Look for rules, see if there's a transcript requirement. All this is a formal evidentiary hearing. This falls under 12569 in the Florida statutes, which basically is a decision tree, whether or not you proceed with this hearing under disputed issue of material fact. Not going to explain that, you know that. If you're proceeding under 12057, you find yourself in the Division of Administrative Hearings. The administrative law judge is the finder of fact, and it's essentially a bench trial. Everything is appealable to the relevant district court of appeals. So while you're having these discussions with your student and with the staff at the school, you want to try to find any kind of alternative to expulsion. And one of these alternative to expulsion is specific to drug offenses. And that is that a student can get a waiver of discipline or expulsion if they offer information leading to the conviction of the supplier, they voluntarily disclose the fact that they have the drugs before they get arrested, and they complete a state licensed drug abuse program. These programs are about 5 days. Lots of schools do them. They know about them. The timing is a little iffy here. The conviction of the supplier is obviously not going to take place, in the next 24 hours. So it's more likely that you would ask the student to disclose and then, do the drug abuse program. So let's talk about the Marjory Stoneman Douglas High School Public Safety Act. I couldn't even fit this whole thing on my title slide. So in 2018, on Valentine's Day, there was still to this day, one of the worst school shootings in the country. It took place at Marjory Stoneman Douglas High School in Parkland, Florida. And immediately that session, 2018, the first law about Marjory Stoneman Douglas and public safety was in place. The law is a moving target. It has been amended and extended 3 times already. So you always want to check for the latest changes. I'm talking about the Marjory Stoneman Douglas Act because it is pervasive in school discipline. Honestly, I can't tell you the number of school meetings I've been in, just sitting in, where school staff say, this is the next school shooter. And you just have to know there is a heightened awareness of all of this stuff. The initial law created the Office of Safe Schools, which is over threat assessments, which include assessments of school safety, assessments of student safety, all kinds of stuff. They are over the Guardian program, which we talked about, armed school staff. They are responsible for a mobile suspicious activity reporting tool, which is called Fortify Florida. And probably the most important thing is this threat assessment process. The Marjory Stoneman Douglas law also, there's also a commission and a series of grand jury reports about the incident at Marjory Stoneman Douglas, and also various recommendations about mental health, about screening students, about the hardening of schools, which is a physical way of making schools safer. They're very critical, both of Broward County, where the incident took place, and the state as a whole. So the legislature tends to respond to them very immediately and with a lot of activity. So threat assessment is an area that's changing right now, and we will update this presentation when we have new information. But right now, they have a standard form that is used. It's from the state of Virginia. It's a very good form as it goes, but it doesn't fit Florida very well. So what a behavioral threat assessment is done by a team, and you can see that it has to have people with expertise in counseling, instruction, school administration, and law enforcement. It now must also include someone who knows the student personally. You notice it does not include anyone with experience in special education. So they're looking at the threat itself. is it just a passing thing? A kid had a meltdown, or is this really substantive? If it's substantive, they need to respond and they need to monitor. So sometimes that response is to get counseling. Sometimes it's to put the child in an alternative setting. There's all kinds of things that are happening. They're not always known. One of the things here is that, and this has just been fixed in the most recent law, there's not a time frame yet. And so that actually won't kick in until about January of 2024. So you can have a student who's being assessed as a threat, sometimes removed from campus for months. So there, like I said, there is a standard tool. It's really long. If you see it, you will think, oh my goodness, this is really, really long. We know that there are problems with this process. We know that students who stick out in any way, they are in foster care, they are homeless, they are in special education, they are assessed much more frequently. And then there's some data that has been used to actually show that it matters what district you're in. In some districts, 10% of the students are assessed as potential threats, whereas in other districts, it's 0.1%. The due process rights of a student here are very unclear. This has not been to the courts yet. The implications for students are obviously quite important because students can be removed from campus, placed on other campuses, surveilled, all kinds of things. And so this is something that we are watching. Just a few tips here on arrests at school. Told you that school guardians and safe school officers have arrest power. The most common arrests on campus are for assault, battery, and disorderly conduct. And I just love this, corrupt the public morals. You can almost always ask for diversion in lieu of arrest. So this was specifically limited under the Marjory Stoneman Douglas Act. It is through the state attorneys, and it does bypass the court process. So the important thing is that this does not end up being an arrest on the student's record. Wanted to talk a little bit about reporting. So SESR, you'll hear SESR reporting, that stands for School Environmental Safety Incident Reporting. You can see why we call it SESR. This is a report of every incident that happens on a school campus or at a school function. And this is also part of a student's record. It is not clear whether this is part of their educational record and so is protected under FERPA. So districts report on 26 incidents. They report 365 days a year, 24/7. And this is actually data that is now reported monthly. And I believe a dashboard is being created. And the idea is that parents want to know that their school campuses are safe. There are politics on over and under reporting. So always take this with a grain of salt. Here are the things that schools have to report, obviously very serious. There are things that schools are expected to report, somewhat less serious. And then there are things that they don't have to report. And, you know, you're never going to get in the conversation where a school says, well, what do you think? Should we report this to SESR? It just gives you kind of a hierarchy of how schools see violence and things like drug abuse and use of tobacco. These factors that influence whether charges are filed are also factors that influence threat assessment teams. So just wanted to sort of lay these out here for you. The severity of offense, your argument obviously is that it was less severe than it's being shown or perceived age of the student. So, and this happens, this is a known phenomenon with students of color, also with students in foster care. It's called adultification. And so you want to remind whoever is making the decision of how young this child is. You know, if they're talking about him as a teenager and he's really 10, you want to emphasize 10. Their past record, the strength of the evidence, always worth questioning. You know, does the video show everything? Who took the video? What was the chain of custody? Do they have a history of home or school problems? Do they have a pretty nasty school attendance record? Is there a parent who is perceived to have control of this child? Or is it up to me in the school? And then gender is a huge issue. Boys are charged way more often. I look forward to the day when we don't have to talk about race, sex, and other characteristics in this way, but it's going to be a minute. Okay, so in terms of advocacy, here are my general tips and tricks. Please advise the parent, the student, the guardian not to sign anything. In general, it signs away their rights to due process, and you may need that due process in order to fight back. Try to slow the process down. If a parent can waive a timeline for a hearing, if they can waive anything that gives you more time to work out options, absolutely waive that. The balance is you're keeping the student out of school versus what are they going to have on their permanent record. So you also want to make sure that they have access to school services. You are always, always, always trying to avoid expulsion. Expulsion is part of the student's permanent record that travels with the student. It has to be reported on college applications, employment applications, character reporting. You may be familiar with the moral character part of the bar exam and all of that. So it sticks with you. One way to avoid expulsion is to look for opportunities in lieu of expulsion. And that's sometimes the case where you might ask, is there a chance the student could go to alternative school in lieu of expulsion? And you still want to make sure it's for as little time as possible under the best conditions possible. If you ask if a student can attend virtual school in lieu of expulsion, just know that virtual school really only works when you have a very committed student who is very self-motivated, will stay on track. It's very easy to get lost on virtual school. And certainly that's something that we all learned during the pandemic. Always check due process. What's followed, what's reported, is everything noticed? Is the notice complete? And always make the district prove its case. The district likes to rush to judgment, and you're there to say, wait just a second. Why is the student a danger on campus? Was this a one-time thing? Why are you saying the student can't be on campus? Is that there isn't a program? Are there not SROs? There are ways to make room for a student on campus. And this is not something a district is going to offer. This is something that has to be pushed. In terms of key inquiry, it's important to distinguish between required and discretionary expulsions. Obviously, you have a lot more leeway, the less, if it's zero tolerance, you got no leeway. If it's totally discretionary, argue your heart out. What were the reasonable efforts? Here's one that is really important. Is this a case where student behavior should have led to a recommendation to evaluate that student for special educational services? We're going to talk a lot about that in another module. It's called Child Find. But when you have a student who shows a pattern of behavior that is troubling, that is a student who should be evaluated for special ed. And obviously, and finally, what are the options to minimize the punishment and the educational disruption? So thank you for hanging in with me. Obviously, I have not given you the keys to the kingdom, but hopefully you understand the context and the process of suspension and expulsion and other school punishments much more. And I hope that this helps you to help kids.